I'm excited to bring us home with our final part 4, our final in the series. So we're going to talk about negotiating like a pro. So let's start where a lot of good lawyers start, which is with definitions. And so today, the definition of negotiate that we're going to use is the verbal process of coming to agreement over the allocation of scarce resources. So it's the verbal process of coming to agreement over the allocation of scarce resources. And so really, we have if you think about it, we have all sorts of negotiations happening in our lives, both personally and professionally, all day long, all the time, with this verbal process of coming to agreement over the allocation of scarce resources. So I'm going to spend some time starting out sharing with you the results of a research study about the behaviors that skilled negotiators tend to employ over average negotiators. We're going to talk about the behaviors that they use and the behaviors that they avoid. And then we're going to add those to some of the key habits and tools that I have learned over more than a decade as a commercial litigator and commercial mediator, to start talking about what are some of the habits that highly effective negotiators can build and practice to negotiate like a pro. All right, so Neil Rackham and John Carlisle, back in 1978, conducted what was at that time a landmark study of face-to-face behaviors that were avoided and utilized by skilled negotiators. So they compared the behaviors of 49 skilled negotiators with those of average negotiators. And they looked at over a total of 103 separate negotiation sessions. The 49 skilled negotiators included union reps, management reps, contract negotiators, and others. And these skilled negotiators were selected based on the following criteria. They were rated as effective by both sides. They had a track record of significant success, and they had a low incidence of implementation failure, meaning the agreements they reached were actually viable and successfully implemented. They weren't just, agreed to at the time and then fell apart afterward. And in this research study, Rackham and Carlisle concluded that skilled negotiators utilize certain types of behaviors significantly more frequently while regularly avoiding other types of behaviors. So let's start with the behaviors that skilled negotiators avoided much more often than average negotiators. So the behaviors that skilled negotiators avoid include irritators, immediate counterproposals, defend and attack spirals, and argument dilution. And I'll dig into each of those a little bit more in detail. So irritators are those gratuitously favorable statements about yourself or your offer. If you say, I have a fair offer for you, or my client's reasonable proposal is, this is what Rackham and Carlisle labeled as an irritator. And they found not only does it not have persuasive value, but it actually can be counterproductive because it can imply that the other side is not reasonable or not being fair by you gratuitously pumping up your proposal or yourself or your proposal. And so skilled negotiators use irritators less frequently than an average negotiator. The second one is an immediate counterproposal. So this is where the counterproposal comes really quickly, and it's perceived as blocking or disagreeing rather than a counterproposal because it comes so quickly and it adds new or additional options really quickly. The other person has the experience of not feeling heard, not feeling like their proposal was given any consideration. And sometimes it can be too complicating and overwhelming, and it's not given at a time that they are most receptive to receiving the counterproposal. So skilled negotiators utilize immediate counterproposals much less frequently than an average negotiator. The third one is defend and attack spirals. And so these are emotional or value-loaded behaviors when they're used to attack or defend. So you can't blame us for that, or it's not our fault that, we're in this situation to begin with, right? These are things that skilled negotiators tend to avoid. Average negotiators might use more frequently. And then the last one I find the most interesting because I see it a lot with the lawyers that I mediate with. And then I did this myself as well as a litigator, argument dilution. And I didn't realize that it's ineffective. So this is when let's say you have 3 reasons that support your argument and you list them all out. You say, here's why I'm right, or here's why this proposal is really good for reasons 1, 2, and 3. Rackham and Carlisle found that is actually less effective because it tends to dilute your strongest argument. And so the other person tends to attack the weakest one and then ignore the strongest argument. And so the skilled negotiators, Rackham and Carlisle found, tended to advance single reasons consistently and insistently, only moving to the subsidiary reason if the main reason was clearly losing ground. So I found that one particularly interesting and insightful because I see it all the time where we list out, 3, 4, 5 reasons to support something. And Rackham and Carlisle found that skilled negotiators actually do that much less frequently than an average negotiator. All right, so we've talked about the behaviors that they found that skilled negotiators avoided. What about the behaviors that skilled negotiators utilize to be more effective? Those include behavior labeling, testing, understanding, and summarizing, seeking information, and giving internal information. What do I mean by behavior labeling? Calling attention in advance to the category of the thing that you're about to discuss. So this might be, can I ask you a question? And then you ask the question. Can I make a suggestion? And then you make a suggestion. Let's talk about implementation. And then you talk about implementation. So it's labeling the topic before you dive into the topic. And this accomplishes a few things. One, it draws the listener's attention to the thing that's going to follow. It slows the negotiation down, giving time for the negotiator who's doing the labeling to gather their thoughts and for the other party to clear their mind from the previous statement and really hone in on what's coming next. There's also an element of social pressure that might make it more likely for the other person to respond because you've drawn their attention, and our social etiquette is such that we tend to listen and feel compelled to answer a question that's being asked of us. And then it reduces ambiguity and leads to clearer communication. Just like the second one, which is testing, understanding, and summarizing. And so this is a compact restatement of the previous points that the other person made to check for understanding and prevent misinformation and misunderstanding. And skilled negotiators behavior label and summarize and reflect back more frequently than average negotiators. The third one is seeking information. Rackham and Carlisle found that skilled negotiators spend 21.3% of their time gathering information, whereas the average negotiator only spent 9.6% of time gathering information. And then the fourth is giving internal information. So in addition to spending more time seeking information, the skilled negotiator spends more time providing information to the other side. This provides the other party a sense of security, and it is it's more likely to, when you provide information and you do it in a way that you maybe frame your concern as instead of outright disagreement, you might say, I'm worried that we seem to be so far apart on this point, instead of disagreeing flatly with it. That can be a much more effective way of posing a challenging issue. So Rackham and Carlisle found that skilled negotiators use behavior labeling, they test for understanding and summarize, they seek information more frequently, and give information more frequently. So with this backdrop and overlay from these excellent researchers, now we're going to look at 6 habits that I recommend you start figuring out how to flex that muscle and build that muscle to incorporate into your negotiations to have more effective negotiations and achieve better outcomes. So we're going to look at prepare. How do we prepare in advance for the mediation? How do we build trust and rapport? How do we manage emotions, both ours and the other people? Analyzing BATNA and WATNA. So BATNA is your best alternative to a negotiated agreement, and WATNA is your worst alternative to a negotiated agreement. How do we use an interest-based negotiation model, and then engage in brainstorming and joint problem solving? So the first three habits are really foundational. They're kind of like pouring the foundation of the house. And then analyzing BATNA and WATNA is a very analytical skill set or habit. And then the last two habits are more about execution and implementation, putting the pieces all together, putting the roof on the house and the paint. So let's look at habit 1, which is prepare. And so this is not only preparing yourself, but also preparing your client. So this is assuming that you are negotiating on behalf of a client. Not only do you need to prepare yourself, but you also need to spend some time preparing your client for the negotiation. So what are some of the things that we want to do as part of our preparation? We want to obviously identify clear goals. If we don't know where we're going, we have less of a chance of getting there. So we want to identify what are the specific goals. What are we really hoping to get out of this negotiation? But we also need to stay flexible. Rackham and Carlisle found that skilled negotiators identified a range as their objective, as opposed to an inflexible fixed dollar amount per se, for example, or one specific fixed outcome as they prepared for negotiation. So having a range actually helped them achieve better outcomes and be more skilled negotiators. And then once you've identified some goals, prioritizing those goals, seeing if you can rank order them in terms of importance, and then imagine what the other side's goals might be. So how do we help our clients identify their goals if they don't know, or if they tell us, I don't know, or they aren't giving us much to work with? These are some of the questions that I think can be helpful to ask our clients or ourselves if we're negotiating on behalf of ourselves. If you had a magic wand, what would the ideal outcome be for you? What do you hope will be different as a result of this negotiation? What is most important to you? What is least important to you? If you had what you really wanted, what would that allow for? These are questions that are going to help us identify the client's goals, but also identify the needs and interests, what's motivating the goal, what's driving their desire for that thing. All right. And then the other really important thing that skilled negotiators do is they don't just spend time preparing their side. They also spend time in advance considering the other side's perspective and what might be important to them. And the reason for this is that in any successful negotiation, both sides need to get to yes. So you need to consider the other side's perspective as part of your preparation, because ultimately your goal is to get them to say yes. And you can't do that without understanding their perspective or possible solutions that might work for them, not only work for your client, but might also work for them. And so you might help your client or yourself think through, what do you think is most important to the other side? What do you think is least important to them? What do you think drives them? What options or solutions might they propose? Maybe it's based on prior options or solutions they've proposed in the past. If they had what they really wanted, what might that allow for? So these are ways to help on the preparation side before you ever get to the negotiation table, to get clear about what your client's goals are, and then to spend some time considering what the other side might be interested in. All right, so habit 2 is building trust and rapport. So this is a crucial component in any negotiation, and it takes time and effort to build. Harvard professor Francis Fry identifies 3 components of trust: authenticity, rigor in one's logic, and empathy. And empathy is commonly defined as the ability to understand and feel what someone else is feeling. And empathy, the research tells us, builds connection and understanding, which are really foundational to an effective negotiation. Nursing scholar Teresa Wiseman has identified 4 qualities of empathy: perspective taking, staying out of judgment, recognizing emotion in other people, and communicating back the emotion you see. So how do we put this into action? Most of it is through our words and our nonverbal communication. In previous parts of this series, we've talked about using open-ended questions. I'll remind you some of the benefits of open-ended questions. They demonstrate genuine interest. They uncover new information. Remember, Rackham and Carlisle talked about and found that skilled negotiators spend more than 2 times as much time seeking information than the average negotiator. Open-ended questions can help dodge defensiveness. They can help empower problem solving by the other person, and they can buy time if you need to. And Rackham and Carlisle identified the advantages of gathering this information to include obtaining the necessary information with which to bargain, giving the person who's spending the time to uncover the new information more control over the discussion. Questions are more acceptable alternatives than outright disagreement, right? So instead of saying, I can't do that, if you posed a question of, how do you think I could make that happen? 1, it's not as much of a direct oppositional disagreement, but 2, it invites the person to come shoulder to shoulder with you and face the problem and jointly problem solve and solve it together. And then questions keep the other party active, reduce their thinking time, and they give negotiators breathing space to allow them to sort of gather their own thoughts. All right, so we're going to build trust and rapport through open-ended questions, and then also through listening with curiosity or listening with purpose. We've also touched on this in the Communicate Like a Pro series, but it's worth repeating because it's so foundational to building that critical trust and rapport in any negotiation. But to really spend time thinking, what are they feeling? What are they needing? What's important to them? What do they value? And where is the common ground? In addition to helping, these questions will help you to ask them questions that gather more information, one of the things that skilled negotiators do. And they will also help you stay out of judgment and evaluation because they give your brain another job to do, right? And that all leads to and builds on empathy, which drives trust, which is connected to building trust. All right, habit 3 is managing emotions. So managing yours and theirs, right? So in every negotiation, I've got the negotiation going on between me and the person I'm negotiating with. I've got the negotiation going on between my ears and the negotiation going on between their ears, right? So there's a lot of human nature at play. There's an outdated view that emotions have no place at the negotiation table. In reality, the research has been updated, and really the things that people care deeply about, that they want to negotiate about, are bound to stir up strong emotions, whether this is power, identity, their livelihood, their reputation. It's going to stir up strong emotions. We are past the point of thinking that there's no room for emotions at the bargaining table, and we need to be able to manage the emotions that inevitably are going to come up, both ours and theirs. So highly effective negotiators have high EQ, meaning they're adept at identifying and managing emotions at the negotiation table. Emotionally intelligent people have the capacity to identify the emotions they are experiencing, as well as the ones that others are experiencing, understand how those emotions affect their thinking, use that knowledge to achieve better outcomes, and productively manage emotions, tempering them or intensifying them as the case may be. So a really interesting research study out of UPenn, Alison Brooks and Maurice Schweitzer of UPenn conducted a study where they had two different groups and they played different types of music to each of them before sending them into a negotiation. With one group, they played really soothing music, and with another group, they played really intense, scary music. And they were looking at the effect of emotions, namely anxiety, on negotiation performance. And so they had these two groups, they played the two different types of music, and then they paired one person from each group to do a simulated negotiation through instant messaging. And the results were really interesting. The anxious subjects, those who had been exposed to the frenetic and scary music, had lower expectations. They made lower initial offers. They responded more quickly to offers, and they exited the bargaining sooner, and they got worse outcomes. And so I thought that was a really interesting experiment to show the importance of emotions and how they play out in negotiations, and the importance of managing our emotions, or our clients' emotions or other people's emotions during negotiation. So what are some of the tools to do that? Remember the role of neurobiology in conflict. I won't recover that ground. We covered that in one of the previous series, but remember that neurobiology is at play, and we may need to take a break, take a breath. Just taking a deep breath can really help clear the mind, can help that prefrontal cortex come back online, which we really need for problem solving. Take a break. So Harvard Program on Negotiation calls this going to the balcony. I like to think that what they meant by that was taking an intermission, like at a performing arts show. And it gives everybody space and time to recalibrate your approach. And then another way to manage emotions is follow Bill Eddy's and make an ear statement. Again, I think we've talked about that briefly in another series, another part of this series, but an ear statement stands for empathy, attention, and respect. And so empathy might look like, I can see how worried you are about this. Attention might be, I'm interested in knowing your point of view, or I want to understand, tell me more. Respect might look like, I respect your efforts at dealing with this problem. Okay, and so those are tools that can help manage emotions as they come up in ourselves and in others at the negotiation table. Another thing to do is anticipate objections in advance. Think through, well, how might their point be valid? Is there anything I can do about that? Acknowledge the concern and ask if they're willing to discuss it. Remember that objections are just strategies to get a need met, or it's a signpost like a flag that there's a care underneath that feels threatened or needs protecting. So identifying it, naming it, and then asking them, would you be willing to discuss? Might you be willing to discuss? The word might is a really powerful word to use in any negotiation, because it opens up the possibility of the thing that follows it without either side committing to it. So it's a good sort of neutral invitation to have a conversation without either side feeling like it's scary or they have to commit to it. It's an exploratory invitational word, and it can be a really effective word to use in any negotiation. So might you be willing to discuss it? Might that work for you? What might work for you? Are all really effective negotiation questions. All right, moving on to habit 4. This is analyzing BATNA and WATNA. So I recommend doing this in advance of the mediation, but of course you could do it during the mediation if you learn during the negotiation. If you learn more, if you learn new information during a negotiation, this may change your analysis or your calculation of your BATNA or your WATNA. But it's really surprising to me how many lawyers skip this step. why might lawyers skip this step? Maybe they were never trained and don't know that BATNA and WATNA exist. Maybe it can be difficult to calculate. So it can be difficult to quantify litigation risk or likelihood of success in court. Maybe there's a denial of the possibility that they'll actually lose. So maybe a denial that WATNA even exists. So remember, BATNA stands for what is your best alternative to a negotiated agreement? If you cannot negotiate an agreement and you have to go litigate, what is your best alternative in court? WATNA is your worst alternative. If you cannot come to a negotiated agreement and you need to go to court, what is the worst alternative? What's the worst possibility that you could end up with in court? And that will often give you two really important data points. Now, they're just data points. They're not the be all and end all, but they are relevant data points to help your client or the other side recognize what are the realistic alternatives if we are not able to keep working on problem solving together. We will likely end up in court if we can't come to a negotiated agreement. And in court, here are our ranges of options. We've got best case scenario in court and worst case scenario in court. And we may fall somewhere in between that range, but that gives us two really important end notes or data points to help guide a potential discussion and perhaps to help keep the parties at the negotiation table when things get tough. So let's do a little example. I'm going to keep it really simple. There's a more detailed example in the manuscript, but for purposes of doing some easy, simple math, let me tell you what you're looking at for your best alternative and your worst alternative is what is the most likely outcome in court? What am I going to get when I win? What am I going to get when I lose? And what's it going to cost me to get to that outcome? So let's take a commercial lease. Let's assume that a plaintiff is a commercial landlord suing a commercial tenant for failure to occupy the commercial space when agreed and to pay the agreed upon rent. Let's assume the commercial tenant acknowledges that it didn't occupy or pay the rent per the lease terms, but it argues that the landlord failed to mitigate its damages by not timely marketing the space and getting a new tenant in. And so let's just assume for easy math and for purposes of this discussion that if the tenant succeeds on its failure to mitigate damages argument, then the unpaid rent damages will be reduced by exactly half of the total unpaid rent. Again, this is just trying to make numbers easy. Let's assume that rent was $2,500 a month. Let's assume the time period was 12 months. And let's, for purposes of easy math, forget about unpaid rent, interest and attorney's fees. Let's just stick with real easy numbers that a year of unpaid rent, 12 months at $2,500 is $30,000. So if the landlord wins, if they go to court, their best day in court is going to be $30,000, the unpaid rent. Let's make it easy and forget about any other contractual rights they may have. What's it going to cost them to win that $30,000? Let's assume that it's going to be $15,000 to get that outcome. So you take what they're going to get, $30,000, minus what it's going to cost, $15,000, and your net is $15,000. So that's the landlord's best alternative in this scenario. Let's look at the flip side. What's the landlord's worst alternative? Let's assume that the tenant prevails on their failure to mitigate damages claim, which under our facts, very nice math for me, it just cuts the damages in half. So that $30,000 of unpaid rent gets reduced down to $15,000, still going to cost them $15,000 to get there. So now their net is zero. So their WATNA is zero. So their BATNA is $15,000 and their WATNA is zero. That helps give relevant data points to help guide the negotiation. So imagine if you hadn't done that analysis, if your client hadn't done that analysis and you didn't know what the possible outcomes in court might be, then that could seriously impact your negotiation strategy. It could also impact whether the other side says yes, right? If you're making a demand that's much greater than your best day in court, it's unlikely that the other side is going to acquiesce to that. All right, so that's analyzing BATNA and WATNA and making sure that you spend some time in advance of the negotiation preparing for the negotiation by running that analysis. And then, of course, if the facts change, if you learn any new information, adjusting your BATNA and your WATNA accordingly as might be needed. All right. Habit 5 is utilizing an interest-based negotiation model. All right. So the U.S. adversarial system is based on a positional-based negotiation model. We make demands. It's a rights and entitlements model. It's the law says that I get all the sticks in the bundle, you get 0 sticks in the bundle. That's the bargaining model. To illustrate an interest-based negotiation model, there is a famous story of the orange. I did not come up with this story. I do not know who to give credit to for it, but it's a story to illustrate an interest-based negotiation model. And the story is that 2 children are both fighting over 1 orange. And, you know, the traditional adversarial model might say, well, who found it first? Who's holding it? Who is entitled to it, right? And it might be a winner takes all, and one child gets the whole orange, the other child gets nothing. Or maybe they go to arbitration and the arbitrator happens to split it down the middle and they each get half of an orange. However, if we had dug further and we had asked each of them, what are you going to do with the orange if you got it? And one child says, I'm going to use the pulp for juice because I'm really thirsty. And the other child says, I'm going to use the rind to zest something that I'm baking with. If we had dug into that and dropped beneath the surface of just the positions of I want the orange, no, I want the orange, if instead we had gotten into the interests of what's driving the position, why do they want the orange, what are they going to do with the orange, then we could have seen that there was possibly a way that one child got all the pulp and the other child got all the rind. And so in that way, they maximize the orange to each get 100% of what they are seeking out of the orange. Okay, that is an interest-based negotiation model. And so it looks at trying to get beneath the positions to what are the underlying needs and interests, what's motivating them to take those positions, to see if we can maximize everybody getting their needs met, to see if we can expand the pie. So essentially, it almost is as if there are 2 oranges because they each get 100% of what they want. Now, I know this example is intended to work, and it doesn't always work in every scenario. You can't always maximize everyone's interests, but that is sort of the representative example of an interest-based negotiation model, and it's distinguished from the traditional positional-based bargaining that we use in our adversarial system. So whenever I talk about an interest-based negotiation model, I like to use the iceberg imagery because I think it really helps illustrate the points that what we see at the top, the behavior or the position or the demand that somebody's making is just really the tip of the iceberg. That when we drop beneath the surface and ask questions that drive at the needs and interests that are motivating the person to take that position or make that demand, there's a lot more under the surface that can help inform us and help see if we can craft a solution, right? So positions are at the surface level. Those are the demands. That's the stated, this is what I want, right? Needs are the fundamental things that all people strive to maintain. Food, water, shelter, reputation, identity, community. And then interests are the deeper desires and emotions in which positions are rooted. So fairness, respect, acknowledgement, value. And the position or the demand that someone makes is usually just a strategy to try to get their interest or their need met. And so often we don't even realize that that's going on. We just think, they've made the demand, that demand doesn't work for me. And so we get stuck at the position level, at the surface level. And it's when we drop beneath the surface to unearth what's driving each of the positions is when we have an opportunity to see, one, is there any common ground? Are there common needs or interests that we can start building some respect and some mutual understanding around? And then two, is there a different position, a different demand, a different strategy that we could propose, a different solution that might help meet both sides' needs instead of just being stuck at the my way or your way? So let me tell you an example from my children. So we were driving to school one day back when they were young enough to be into Frozen 1, and I have two girls. The younger one said, I want to listen to the Frozen 1 soundtrack. And the older one said, oh, no, I don't want to listen to Frozen 1. So they're stuck at listen to Frozen 1, don't listen to Frozen 1. And of course, they want me to be the arbitrator. I had no interest that morning in being the arbitrator. And so I engaged in an interest-based negotiation with them. And I said to the younger one who wanted to listen to Frozen 1, could you tell your sister or tell us why you want Frozen 1? What do you like about Frozen 1? Oh, I just love Frozen 1. I love the soundtrack. I love Let It Go. And then I said to the older one, could you tell your sister what you don't like about Frozen 1? How come you don't want to listen to Frozen 1 today? And she said, well, I really don't like the first song on the soundtrack. So I'm willing to listen to Frozen 1 if we started on the second song, right? And so by dropping beneath the surface, they could explain to each other what was motivating them to take each of those positions. And they, on their own, found a solution that, by the way, would have never occurred to me. It would have never occurred to me to start the soundtrack on song number 2. I'm just not that creative. And they found a solution that worked for both of them. And so that's just a very simple example of an interest-based negotiation model. And Rackham and Carlisle found that skilled negotiators gave over 3 times as much attention to common ground areas as did average negotiators, right? And so dropping beneath the surface is where you're going to find the potential for common ground. All right, so how do we help uncover the interests? By asking questions. So we go back to Rackham and Carlisle, we gather information, we use open-ended questions, and we start to uncover the interests. We can say things like, help me understand what's important to you about having X, right? Like, I want $1 million. Help me understand what's important to you about having $1 million. If you had $1 million, how would that help? What would that allow for? What would that mean to you? These are all questions that will dig underneath the surface and help uncover the need or the interest that's driving the strategy that the particular person has taken, right? The strategy is, I demand $1 million, but there's something under the surface of the water that is driving that. And if we can uncover the interests, one, we can summarize and reflect them back, like Rackham and Carlisle say skilled negotiators do. And then two, we can start seeing if there's any common ground and any way that we can expand the pie to get their needs or interests met, just maybe in a different way than the demand that they're making that doesn't work for us. All right. Habit 6 is engage in brainstorming and joint problem solving. Okay, so now we're going to take everything we've learned so far, build the foundation, and we've uncovered some of the interests, and now we're going to brainstorm options that will work for both parties and engage in joint problem solving. So we're going to turn it from my way versus your way, where we get stuck and our horns get locked, and we're going to find the third way or the fourth way, right? We're going to find other options that might work. Okay, so how do we do this? We build on everything that we've learned so far. We're going to listen with purpose. We're going to ask open-ended questions, reflect back feelings and identify needs. That could also just be the summarizing back that Rackham and Carlisle say skilled negotiators do. We're going to put all the possible options on the board without evaluation or judgment. This is really hard to do. It's really hard to, judging and evaluating is human nature. And so somebody proposes an idea and we immediately shoot it down and talk about all the reasons why it's not going to work. We need to, for as much as possible, if we're trying to brainstorm solutions, pause the evaluation and judgment, knowing that there will definitely be a time to evaluate our options and see if they're going to be viable or not. But it's just not yet, because it will quench the creativity if we start cutting down each other's ideas. And then use the phraseology of what might work for you and would you be willing to, okay? So let's use an example of, let's say we have neighbors who have a dispute about a fence, and one neighbor wants the fence, the other neighbor wants the fence to come down. And so we would dig in and ask questions like, why, what is it about the fence that bothers you? What is it about the fence that you like? These will help us figure out, is it a privacy concern? Is it a noise concern? Is it a aesthetics concern? Is it a monetary concern? What is the concern or concerns driving the positions that don't work, so that one, they can hear each other and understand each other better. Two, see where there might be any possible common ground. Do they both agree that privacy is important to them? Can they build on common ground there? And then three, see if there's any options that we could put on the table that might address both sides' needs or interests. Okay. Let me tell you a story about the fence in my house. I had a 5-year impasse with my husband about a physical fence in our yard. The house when we moved in did not have a physical fence. It had an electronic fence, or like the dog collar could be connected to the electronic fence, but it didn't have a physical fence. And so we had young children, 2 dogs at the time, and I wanted a physical fence. He did not want a physical fence. Before I learned these tools and techniques, we had a 5-year impasse where we were stuck. For those of you who are paying extra attention, you will note that the status quo was in his favor because he benefited from getting what he wanted for the 5 years that we did not have the fence. So I recognize that sometimes status quo does benefit one party or the other. That's not what we're talking about today, but it happens to be part of my fact pattern. And so once I learned these tools and techniques about how to drop below the surface and stop thinking that my husband, who I love dearly, was being a selfish jerk by not engaging in dialogue to have this fence, we were able to have a conversation. And what that conversation, through open-ended questions and curiosity, revealed was that he didn't want the hassle of finding a vendor, picking out the fence, dealing with the vendor, dealing with the HOA approval. He didn't want the cost of the fence. He grew up in a rural part of the country where they didn't have fences and kids ran free. He also grew up really poor. And so the thought of the cost of this fence was not something that he wanted to deal with. He also thought, well, we have the electronic fence for the dogs, so what's the problem? And, of course, we joke that, well, we don't put the shock collar on the kids, so it doesn't help solve the kid problem. with the kid, not the kid problem, but the security of the kids. And then on my side, I grew up in a city. So I grew up around lots of, busy streets, and I was used to having a fence. And I was very concerned about my young children and the corner lot that we were on going out of multiple different doors and me not knowing which one they went out of and them running into the street. And so we were able to drop beneath the surface and identify that the common ground was we each had a need for security. We just expressed it differently. He had a need for financial security. I had a need for physical security. It just got expressed differently. And so the strategies that each of us chose to get our needs met were just different and didn't work. But once we dropped below the surface and could relate to each other's need for security, because we each had a need for security, it helped unlock things, and it helped us brainstorm some options for how we might find a solution and build it in a way that worked for both of us, right? And so part of the solution was saving up over time the money so that he felt comfortable with that I would take the lead on the legwork and all the hard part, the annoying part that he didn't want to deal with. And long story short, we have a lovely fence. Oh, he was also concerned about the aesthetics and where the fence was going to cut the property. But now he says that it turned out better than he thought it was going to. So that's just an example of how an interest-based negotiation model can help find a solution that works for the parties and maintains a really strong relationship of the parties going forward. So let me pause there for a minute. If there are any questions that you have, please feel free to put them in the Q&A. I see a couple. Sorry, I missed them earlier. Yeah, I think a brief is different. So the question is when you are writing a brief, should you not worry about the argument dilution issue? I'm sorry, I didn't see this Q&A, this question until we had already talked about the argument dilution point. Rackham and Carlisle's research was on face-to-face live negotiations. And so I do think that there is a distinction between a written brief and a face-to-face live negotiation. So please do not hear me say that you should not lay out all your arguments in a written brief. I think you still should do that. I think Rackham and Carlisle's research was limited to face-to-face negotiations. And I think in a face-to-face setting, I've seen this play out as a mediator where I'll carry, because somebody tells me their point and there are 3 points that support it, I'll carry it in face-to-face to the other room, and the attorney in there will attack the weakest one, ignore all the rest, and then I have nothing to work with. And so I think the face-to-face piece of that really does make a difference. So I think you still make all your points, and I don't think it's argument dilution. At least Rackham and Carlisle weren't looking at written briefs. So keep making all your points in your briefs. All right, let me read the Q&A. Yeah, so this is a really good question. When you're talking about empathy and understanding the opposing side, but it's attorney to attorney, and it's maybe detached or less emotional because you're representing somebody else's interests, how do you sort of deal with that? So I think it is more difficult. So it's more difficult to get to the needs and interests of somebody through the representative, right? Because the representative may not know. But I do think that it still is important to build the empathy and convey understanding of the situation, guess at what their client might be feeling or needing, because that might resonate with the lawyer, right? If I'm trying to think of an example, but let's say that there's an inheritance dispute and the issue is the homestead where dad died and where everybody grew up. That's the family home and everybody has great memories of it, right? Acknowledging that, even through attorneys, can be really important to make sure that they then can convey that to the client, that everybody understands this is a really sentimental piece of property and this is really hard. And here are some ideas for how we can figure out where to go from here, right? So I think that it is probably more important and more and easier when you're not going through a conduit, through a representative, but it's still important to check for understanding, summarize, reflect back, and then get to what's underneath the position, right? Help me understand why your client is demanding more than 50% of the estate when the will says 50-50, right? I really want to understand that so that I can go back to my client and help them understand so that we can respond, right? Can you describe the different dynamics of real-time negotiations in contrast with email or text negotiations? So that's really tough. Definitely the presentation today is more geared towards real-time negotiations. I don't do a lot of text negotiating, but certainly I see email negotiations happening. I think the challenge there is misunderstanding and misconstruing things and reading into tone or reading tone into it that's not there. I'm trying to think. I think it's really hard to establish trust and rapport through an electronic device. So I would encourage you to pick up the phone if you could, even if it's have the conversation first and then confirm with a follow-up email. There's just something about the live interaction that helps build the trust and rapport, helps show the empathy. But the research that I'm basing all this on is the live interaction. I don't understand your question. Should you get them to sign off on certain things at any point? I'm not sure I understand that question. The research is cited in the manuscript. So if you want to look into that, I've cited it on the first two slides. You have access to the slides. It's also cited in the written manuscript. All right, and then wrapping up. Oh, we got to wrap up. Go ahead.
No, you can finish up if you got a couple more things. We got a little. I can
okay, just sort of a final point is the importance of debriefing and self-reflecting after a negotiation. And asking yourself what went well, what was unexpected, what did I learn, what would I do differently next time? Just that important continuing to grow and learn process. I know it's difficult to work that in to our busy schedules, and I know that it's not billable, but it will help make you a more effective negotiator if you spend a few minutes at the end of each negotiation reflecting back on, what went well, what was a curveball, what might I do differently next time to learn, grow, and keep improving.